The last session of the Standing Committee on the Law of Patent finished with very positive achievements in the different agenda items. Not only the discussions were very fruitful, but also future work was able to be agreed in a very interesting agenda that will be the agenda of the next meeting. And on this occasion, like in previous session of the committee, delegation were able to agree in a very rich agenda. During this session, I will name few of the areas that, in my view, deserve very special comments. One of those is in the area of exceptional limitations. A very relevant document on the research exception was prepared by the Secretariat and discussed during the meeting. The committee made very positive comments to that document and request the Secretariat to prepare a new one on compulsory license that is going to be discussed next session. In the area of quality of patents, we have very interesting discussions about work sharing and other mechanisms of collaboration between patent offices in search and examination. And we have a very interesting session on the measures that have been implemented in different patent offices in order to ensure quality. And in this regard, also we discuss a third document on inventive step that is one of the most complex requirements of patentability. The committee requests us to prepare a further study on inventive step in other issues not covered in previous study that is going to be discussed in the next session. On the area of innovation and the way innovation impact health technologies and access to medicine and how patents play a role in that area, important discussions took place on this meeting, particularly on the availability of certain databases and the legal status of information contained in those databases. The committee requests us to continue that discussion because there is a number of issues that needs to be learned about how those databases work and how we can improve the databases that exist. On the area of transfer of technology, we were requested to continue compiling information on different patent law provisions that promote transfer of technology, like those related to the licensing of patent rights, and particular laws that promote transfer of technology, spin-off and start-out, and audit of provision of this nature. And finally, in the area of client attorney privilege, we progress in a very important manner in the understanding of the difficulties that patent agents are facing today, because in many jurisdictions, only patent attorneys, when they are attorneys at law, enjoy this confidentiality of communications with the clients. But when patent agents are of a different background, like engineers, for example, there is no protection for such information. The principal area of analysis is when it comes to cross-border litigation that involve this privilege, how patents laws are equipped to deal with those different. The committee is progressing substantively in this discussion, and in my view, we'll be able to move forward soon in that particular field as in the others. So the news coming from this session are very positive, and the next session looks as very interesting one.